You are live.
Good morning and welcome to the July 2nd, 2025 meeting of the COLEG Administration Committee. I'm Nancy Reagan in Albany, and with us today are fellow committee member Claudia Edwards and a couple of additional commissioners, Commissioner James Karras in New York, Commissioner Dolly Carballo joining us remotely, Chair Seymour James joining us remotely. Oh, and I think I now see Vice Chair Ava Ayers joining us remotely. So welcome all and welcome to those public watching this. I'm now going to turn it over to the Executive Director to do the meeting.
Sure, I will. Yes, this meeting is being held pursuant to notice and in accordance with the provisions of the state's open meetings law and executive law section 94. Both the meeting room that we're using here in New York in the State Conference Center at 25 Weaver Street in Manhattan, and the conference room, the Commission's offices at 540 Broadway in Albany are open to the public during public session. The meeting is also being live streamed and can be observed using the link on the Commission's website at ethics.ny.gov. And I should add that Commissioner Austin, who's a member of the Administration Committee, is participating in the meeting remotely pursuant to the Commission's rules and regulations under Public Officers Law Section 103-8 for remote participation where there are circumstances, and there is a for the committee meeting.
Okay, thank you. I just want to be clear. Can anybody see where Commissioner Austin is? I mean, how he's not showing up on the screen.
I don't
just so
see him yet. Let me
can,
log in and I can see.
okay, but we will wait for that.
He's showing up on our. He's showing up on our.
Okay. Oh, great. Okay. Well, then
He's on WebEx.
okay. Good morning, Commissioner Austin, even though we can't
Good
see
morning.
you at all.
Thank you.
There it is. So I would like to, we have one item on the open session of our meeting today, which is to secure hopefully final committee action on the proposed meetings policy that the Commission has been discussing for quite some time in a number of different iterations. What I'd like to do at this meeting, I think because each of us has seen this document in one iteration or another, and presumably people are fairly familiar with it, I'd like to go through it as quickly as we could, but and in order in which the provisions appear, focusing on a couple of items in particular when we get there. The rules of order, which is something that's been floating around in various iterations, but I don't believe has ever had a full discussion of this iteration of the language. A quick discussion about how we do with the agenda materials. Some questions about executive session, which we may have to defer to an executive session of this meeting because there are a couple of issues that get into legal advice that we need from our general counsel. So when we get to that, to the extent we're talking about how we go into executive session, I'd like to take that conversation offline for now. Then we've come up with a way to simplify our minutes in this meeting. We need to discuss that. Questions surrounding abstention, whether or not a member needs to state a reason for abstention. I know there's some disagreement on that, so I want to have a full discussion of that. And the last thing would be that last section of the document, which I know some people think maybe is unwarranted, the conduct expected of members. I've received some very good comments from some of the members, so unless anybody objects to proceeding that way, I'm prepared to start. Any objection?
You're the chair.
Okay. There's nothing, I don't think, really to say about the opening paragraph. That's just intended to be a a concise summary of why we were created and what we are, the degree of transparency we as a body are committed to, reaffirming that. We've said it in other documents, but I think it's imperative that it be understood that the COLIG, this commission more than any other body, I think has an enhanced obligation to proceed transparently. And so I thought it was appropriate to include that in the opening of this about how we do meetings. It also is intended to balance the competing obligations of confidentiality with the competing concerns of transparency and confidentiality, which the nature of our work requires much of it be confidential. Any concerns with that language? Hearing none, we'll move on to the rules of order. This dates back to a couple of meetings ago where at one of our meetings, a question was asked, just the extent of the applicability of Robert's Rules of Order to our meeting. The matter was referred to the Administration Committee months ago. There was a discussion, and this paragraph that you see here was my attempt after watching that discussion to synthesize what I heard said among the prior members of the admin committee, namely that the overarching goal for any set of rules of order is that the discussions of the body be, fair, efficient, and democratic. And to that end, Robert's Rules of Orders helps to promote that. However, we in our experience have found, I think that on occasion, rigid adherence to the rules of order has sometimes caused us to. I'm sorry, Sandy. Did you have something? I'm sorry.
No. It was just, there's some additional material, so having brought into the meeting room.
Oh, okay. The second sentence was designed to get to the fact that there are times when, in our experience, Robert's rules can basically impede our efficiency by, causing us to sit there and say, wait a second, who abstained, who can't do this, how do we go back and do things? When we all know the desired outcome, we didn't want to have the technical application of the rules of order frustrate that. And so this was an attempt to memorialize that thinking. Before getting comments from anybody else, I'd like to ask our general counsel and the designated parliamentarian if he has any concerns about this language.
Under the rules of order?
Correct.
Yeah.
He said he did not. Okay. Does anybody have any concerns about the crafting and the wording of this provision?
Don't distribute it yet.
Hearing no concerns, I'll move on. One thing I will say, if I'm not giving people enough time to respond, I know I taught one semester in law school and was told, when you ask if anybody has any questions, you have to give people enough time to ask a question. But I'm assuming with this group, no one's shy, so if I don't hear anything.
Hey, Nancy, can you hear me?
I can hear you, Ava.
Oh, sorry. I had myself muted with an unusual mute tool that I didn't know about. There's a secret mute button on my laptop. I just wanted to point out, this is cosmetic, I'm sure, but the sentence says, will ensure that the commission meetings are fair, efficient, and democratic. But the exception to Robert's rules is only for where it's inconsistent with efficient decision making, which sounds like we're making a point of saying that we won't make an exception where it's unfair or undemocratic. So I would just add to the end.
I would take democratic out.
Okay. Does taking democratic, but Commissioner Ayers' comment, I believe, related to the phrase efficiency, not democratic so much.
Yeah, I think I agree with Len. It's a good idea to delete democratic from that first big clause, but then thank you. And then I would add at the end, inconsistent with fair or efficient decision making.
Oh,
That's overstating it.
yeah.
Or you can't be
That's
fair
fine.
and efficient?
Nope, well, that's our objective, so. Okay, so with the following two revisions to that section, with the first being in the second line, the "and democratic" has been removed. And in the second to last line, it will now read, would be inconsistent with fair or efficient decision-making. With
I
those
would
revisions-
make it fair or efficient in the second line. Fair and efficient, excuse me.
Yeah, well, that happens when I remove the "and" limit. Got it. Okay, any other revisions?
I see a typo. Is it in my draft?
We've got
What
it.
I think is it? Okay, it's
yeah,
taken care of. Okay.
Yeah.
Thank you.
Thank you. Okay, open meetings law compliance. I want to explain why this is in here the way it is.
Nancy?
Yes, Ava.
I'm really sorry. The final sentence in that last one, I just also wanted to say the one about the commission's general counsel shall be parliamentarian.
Yeah.
I think usually it should be the executive director who assigns roles within the staff.
Okay, that's fine. There's an earlier draft that says that says.
Oh, am I looking at the wrong one? I'm sorry.
No, you are looking at the draft I was handed by. There is an earlier draft that said the last sentence read, the commission's general counsel shall be the parliamentarian, and then nope, that's the wrong one. There's one that said the executive director shall designate a parliamentarian.
Well, it
There's
says
one
will
that
be
said-
appointed by the executive director.
Yes. There is a version
Okay.
that says that.
Yeah.
Is that the version people would prefer?
I would
Yes?
suggest.
I mean,
Yes or no? I mean,
I would personally,
I just-
but I'm comfortable deferring to Sandy on that if he feels it's consistent with his prerogatives. I just think it should be generally the ED who decides what jobs staff do.
I would suggest, though, since it impacts the running of the meeting at which the chair is responsible, that it would be the executive director appoints in consultation with the chair.
Sure.
I think that is, I would agree that to be more appropriate.
Great.
Okay, so the final sentence will be replaced with the executive director in consultation with the chair shall appoint the parliamentarian. Acceptable?
Great.
Great.
Thank you so much.
On to open meetings law compliance. Why? This is kind of a selective restatement of various provisions of the open meetings law. And I know we have different policies, at least I know we have oil policy, but I don't know that we've ever adopted a policy that reflects the fact that COLI, unlike the prior iterations of the state's ethics commissions, is now subject to the open meetings law. And rather than just state that we're subject to the open meetings law, I wanted to lift out of the laws those sections where I thought it would be helpful, mostly to the public who's looking at these documents to understand how we operate, but to ourselves as well, what it really means for us. So to work into the definition of a quorum, that in our case, a quorum means 6 members. Do the arithmetic that's required. Executive session. I just thought that was important to put that out there, knowing that it's a key part of most of our meetings, given the nature of the confidential of our work. When you go on to page 2 with other pieces of information that relate back to the open meetings law, on section 3, the timing of the meetings, that we have 2 sources of law that speak to the timing of our agency. First is one under the Executive Law 94 that says the commission shall meet at least quarterly. Sandy pointed out that there's the provision in the lobbying law that requires the commission to meet at least once during every biannual monthly lobbying reporting period, which means at least 6 times a year. So he has suggested a revision that reflects the greater number of required meetings being 6 rather than 4. The two meetings can obviously be, for the 2 purposes, can be held together. So that's why that change is there. Okay. Notice is just included in here to remind everybody of the obligation, not that anyone needs reminding of the obligation, but that the notice of our meetings will be conspicuously posted. The location in paragraph.
Can I just make, I think the public or the open meetings law provides that or as soon as practicable in case of meetings called last minute, like some committee meetings are.
Oh, okay. So, or as soon as, right, at least 72 hours before, or as soon as practical.
Yeah, I think it's practical. I'll check the language.
I can check.
Yeah, I just want to have that little
Flexibility.
caveat, like if,
Sure,
yeah,
no,
flexibility in
absolutely.
case we have a last minute meeting.
The location, all this does is specifies where we actually tend to meet, not just say we do meet. Webcasting and recording, that becomes important to include in here because when we get to this section on how we do the minutes, because we do keep a record of the webcasting, it gives us a means to point to specific parts of our meetings that the webcasting record, which becomes a record of the agency. So that's why I thought it was helpful to put that in here. And the use of technology, not that we often have members of the public attend, but I do think it's important that we have it right here in this policy, what they're permitted to do, so that there's not a need to scramble as to what they might ask to do. That's why those provisions are in there. Are there any comments on the section called timing and notice, other than the one requested by Emily to add or to the extent practical language to the timing of the notice? Okay, then we'll move on to the agenda materials and preparation. It's long in the practice, as you see in paragraph A of this section, for the executive director in consultation with the chair to put the meeting materials together. That continues in this iteration. The next paragraph, I've received a number of comments on that says, any member may suggest an item for the agenda by notifying the chair and or the executive director. However, the executive director in consultation with the chair retains the authority to decide when the suggested item is added to the agenda. I think there's a lot of people who have some thinking on this. I believe Commissioner Edwards had some thought. I know Commissioner Karras has some thoughts. So if either of you want to speak at this point, now's a good opportunity.
I'm not able to just reading it again. So any member by the chair, other members. I don't understand the other members. I thought that was just too wordy. Any member can notify a chair, the chair, or the executive director. Why would I notify another member?
Oh, right. So I think that can come out. That can come out. The reason I put, when I was drafting this, the reason I put other members in was just as almost a courtesy to the other members that they know what's even out there in the universe of things that are being suggested. It wasn't to give them that was a notice and a courtesy to the other members. The decision-making process, though, about whether or not it gets on the agenda was, the goal was to vest that, the decision-making authority in the chair and together with the ED.
I agree, but I just think you cover that when you say any member. Any member may suggest to the two officers, but the executive director in consultation with the chair makes the final decision. I just don't think other members at the end of this line here is necessary.
At the
Yeah,
end of-
Nancy, I would delete other members because
It's gone.
that makes it sound like, yeah, it's
It's
gone.
gone. Okay, what do you guys look at? I'm looking at my comments, who asked me to speak on that.
This is a cleaned up version.
Okay.
of-
So it's fine as it stands.
Yeah.
Oh, I've just had some clarification come from Emily that the comments you submitted have been incorporated into the draft that's been submitted. I didn't know that. Thank you for doing that. Sorry for the confusion, folks. So yes.
Okay.
Well, I guess, so the simple question is.
My only concern about that is that I was only making suggestions to the admin chair regarding my thoughts. I don't necessarily think it should be changed because of that without discussion. So we're looking at, it looks like a final draft that you've submitted, but some of the comments is sort of talking things through. So I don't,
That's one of the virtues or weaknesses of SharePoint.
it has to make the change.
If you make the change is in the shared document.
I see.
I could see, well, this is an aside, and can I just say, I think there's great value in us trying to find ways to share documents, but I know, I'm quickly gonna raise my hand. I'm not good at using SharePoint, and I don't know all the features of SharePoint, and I don't know if others are. But it seems to me, if we're not all on the same page, it would be a useful use of our time at some point, not today, to give us a quick tutorial on SharePoint.
Sure.
Yeah.
Thank you. So again, I apologize for not knowing that. But so relative to, and for the rest of this meeting, I'm just going to call everybody by their first name, unless there's an objection. Good. So going back to Claudia's point, the question is, if you've got an agenda item suggestion, do you just notify the chair and the ED, or do you at the same time copy your fellow commissioners? I think if you're doing it by email, the simple way to do that is just who you put on the to line to the chair and the ED and CC the other commissioners, and probably Emily and a bunch of other people. But I don't feel strongly. Is there a strong opinion among the members of the commission or the committee?
If you don't mind my offer of some advice, I can appreciate the value in simultaneously noticing or notifying the other commissioners, because that may spark some conversation or discussion by those other commissioners, which might inform the executive director and the chair as to whether or not the proposed additional item ought to actually make it on an agenda. So the chair and the ED may welcome the thoughts of other commissioners in arriving at their separate and independent somewhat decision. So that's just a consideration.
Dolly? Oh, but by the way, Keith, before you, Dolly, Keith, thank you. And know that while I'm acting in this role as chair of this committee, I welcome the insertion of the advice of counsel at any time without being acknowledged. Thank you, Keith.
Thanks.
Dolly? Oh, well, Dolly and then Sandy.
So I had taken that out because I don't know what role that plays in our, in the section of our agenda that is new and additional items. So that means, does that mean you can't bring up a new and additional item unless it's been approved? So that was the
I-
reason I took it. I didn't think we needed that there, but
That's, you know, I thought that when I was writing this, I thought about that. How do the two intersect? And what my thinking was that if you're in a meeting and you know there's something you want to raise, that comes up under new items. If, however, after you've left a meeting and you say, or in between meetings, particularly as we're going to go through this longer hiatus where we don't meet in August, if you think of something that said, you know, that maybe should be an agenda item. I was trying to think of a way for it to get out there and not forget about it. So no, it was not, when I crafted this, it was not intended to exclude the ability of members to bring up new matters at that time.
okay.
I'll defer.
Sandy,
So
you
does
had a
that
comment?
need clarification, I guess, is what I'm asking? Does that require?
I don't think so, because why I would say that is the way this draft doesn't go through the mandatory components of an agenda, like a call to order, new business, old business. It doesn't do that. It's not at that level of detail. And yes, there's an element of subjectivity as to what's included and what's not. But I don't think that needs any clarification. To the extent you think it would benefit from clarification, I don't see any reason why it couldn't read as would be amended, you know. And then an additional sentence in that paragraph that said, nothing in this sentence precludes a member from raising items during the new and other business portion of the meeting. If you want that in there, it could be.
Yeah, I think I would like, I could throw a sentence in and see if you guys are okay with it. Something like that. I think that's the right sentence, yeah. Because I think it's a little confusing to me. I mean, maybe it's not to other people, but I'm like, okay,
But here's what I was going to suggest, unless anybody has an objection, and it relates back to my confusion with multiple versions of documents. I am happy. I'm taking notes on all the revisions that are suggested and I believe agreed to. I'm happy to go in after this meeting and add all the revisions I think we're agreeing to, so that others don't have to take their time to do it, until we don't have multiple versions floating around. Any objection?
No.
No.
Okay.
Oh, but Nancy, a quick comment on that.
Yeah. Oh, yeah. And then Ava go, and then I know Sandy had wanted to speak. Yes, Ava.
It's just a brief response to that. I'm making some very small wording suggestions in the SharePoint version of the document, which I believe you'll see next time you open it. I'm trying to save everybody the time on the meeting. I hope that's helpful, but if anybody objects, let me know. And if you have trouble finding it, let me know and I'll send it to you.
The only person who objects is me, because that will make my head explode.
Well,
just saying.
But
Only because, again, it's just my limited ability. The other thing we could do is I could call you after this meeting and you could put in the few things that are you in the shared point document now? As we go through this, are you entering the things we're talking about?
why don't I do that, and then that way I'll be the recorder for this meeting, and that will save you the trouble of chairing it and recording at the same time.
That would be great.
Okay.
Yes, but
and I'll download a copy and email it to you after the meeting so that you know for sure which one it is.
That's fine, and again, I think not just for this meeting, but for how we do things, I think we should always know who's responsible for recording things and making changes, so that we don't end up with multiple iterations. So thank you, Ava, for doing that. I really appreciate it. Okay, so are we agreed as the body here today, though, that the sentence suggested by Dolly added to the end that nothing precludes a member from raising it during the new business section of the meeting.
Just one observation.
Yes.
Yeah, if I may. I don't think there needs to be a formal procedure or requirements for making a suggestion, at least from my perspective. I imagine the chair feels the same way. If anybody has a suggestion for the agenda, or wants to have a discussion about the agenda, I'm always available to have that discussion. And I don't know that it's necessary, if somebody wants to bring it up, to find out if it's something that's maybe previously been considered or is coming up in the future. I don't know that it's necessary to have, a commission-wide discussion about it, at least from my perspective. If others feel that that's a necessary gatekeeping function here.
Can I share my thinking on that? Why I put something like this in? Again, this document reflects the long history of our meeting practices and things that have gone on at different times. This commission has evolved greatly and matured well, I think, over time. But I remember a time where there was a sense among, I think, many of the members that items got onto the agenda and we never knew where they came from. And so this was intended to let both members know how they get an item on the agenda, and those members who want to know what items are being put on the agenda are getting put on the agenda. That's all it was intended to do. I agree, our current process, informally, it may work very well now, but it was a consideration at one time, and I think just memorializing a process that is working well is not a bad idea. The other thing I would say, though, is that the notice to the others, while Keith said it may spark a conversation, it may, and that's a good thing. But the more important thing is that it's notice. It's just that you know that it's out there. But if I would turn to the members here, primarily the members here, to see what they think. Is that an unnecessary provision?
Well, my only view is no member of the commission should feel inhibited in passing along a question about an agenda item or suggestion for an agenda item, or whether or not they can ask a question about whether it would be appropriate to make a suggestion out of concern that it will prompt a discussion that, maybe is premature or unnecessary. But if others feel that this is not going to be inhibiting, then fine. I think the practice up to now, to the extent we're memorializing, it's informal. Anyone who wants to make a recommendation for an agenda item can do so. But I get it. I mean, if we want to have an audit trail, if you will, for
Thank you, Sam.
the agenda, that's the way to do it.
I have two people who I know want to speak. The first is Ava and the second is Dahlia, and then I just saw Claudia. So Ava first. Oh,
Okay,
then Jim.
Thanks,
Ava?
and Seymour too. Yeah, I just wanted to say briefly that taking your point, Nancy, that this is a useful guide for new members who are not familiar with our procedures. I think Dahlia's point is helpful, and I would just add a sentence that says any member can also raise new matters during the new and other business portion of an agenda. Just so a new member who reads this thinks like, how do I get this? Okay, great. Sandy's point about informality, I don't have strong feelings on. I can see why one would not want to require that you email the entire commission before having a conversation with Sandy where you say, hey, I'd like for us to discuss this. So I'm sympathetic to that point. Thanks.
So my concern is, okay, so let's say I want to put something on the agenda, right? And I bring it up to Sandy and to Seymour, and they decide, no, it shouldn't be on there, right? So then I bring it up as new and new business. I mean, it just seems, I probably wouldn't do that if you said you didn't want it on the agenda, but I'm trying to think of a of an item that would be prohibited from being on the agenda. So that's why I take issue with that point B. That's what it feels like to me. Like, you know, no one is precluded from bringing anything up on the agenda. Maybe it's long and maybe it's not appropriate for that meeting in the new business section, but that's why I think it's unnecessary. So I just wanted to explain further why I think it's a little bit confusing. So thank you.
Jim? And then Seymour? Oh, no, Commissioner, all right, so is it Claudia next? Claudia?
I think that this should be included in that. Two things. Is the difference between policy and practice. And that we're trying to establish policy. And I think that it should be real clear that while members may recommend certain agenda items, the final decision should rest with the executive director in consultation with the chair. I think that's very different from new business. I think we're looking at a current agenda, and the executive director and the chair are looking at the totality of the meeting, the time frame in which everything needs to take place, and they should make that final decision. New business is something that has not been discussed, and a member would like to have it on the agenda. That's something I think should be under new business and not necessarily consistent with the policy around who makes a decision about what's on the agenda. Now, I'll give you an example. When I was working on the Education Committee's report, and I was very passionate about wanting to have a conversation at the board level with regard to the communications of what we do to the public. Sandy didn't necessarily think it was appropriate at the time, and I understood that. And I think he should have the right to make the final decision. And we agreed we'd bring it up under new business at a time that's more appropriate for the committee. We were dealing with the lawsuit and there were so many other pending issues. It wasn't appropriate for me to ask for that issue to be placed on the agenda at the time. And I think that there should be a policy that lays out, regardless of whether or not, I mean, we are open to make any suggestion that we want, and we appreciate that open environment, but ultimately, final decision should rest with the executive director and in consultation with the chair. So because of that, I think that this should be included. And it was regard to Dolly's concern, it's new business is an agenda item is a standing general item. It's a standing agenda item where you always have the opportunity to pose or present new business you'd like to have presented. So the question is, must it be addressed? Or is that also at the discretion of the chair and the executive director?
That's a part, in terms of raising an item under new business, that's a matter, I guess we would look at Robert's Rules of Order.
I was just going to defer to Keith, the parliamentarian, about how to handle, what are the rules on handling new business. If you don't know right this minute,
Yeah,
I
I
don't
want
want
to
to
take some time to
sidetrack.
study.
Yeah, unless anybody, I know we have some other Roberts mavens on the commission. If anybody else thinks they might know the answer. Huh, the maven's not speaking.
We have not been restrictive in our treatment of new business. So it's something that's not we've generally, if it's not something that's otherwise been on the agenda, I can't think of an instance in which it's been ruled out of order. There have been instances in which the chair has directed or the body has directed that it go back to a committee or be considered at a future meeting.
I would also submit that one of the reasons we agreed to craft the application of Robert's rules the way we just talked about was to not tie ourselves up in knots that defeat getting the business done. It would seem to me, if we know there's a concern about getting items before the commission. It seems that we would understand, we make maximum use of the new business provision of every meeting, and then decide at that time, in the context of that meeting, with respect to the item that's raised, how to handle it. That seems to me a way to handle it that wouldn't require any further amendment to this policy other than the one Dolly had originally suggested and Ava had were recrafted in a way to add to the end of that paragraph. Is that fair? Did I say?
I think that works. I think to the extent Commissioner Caraballo is concerned, which I understand, is that one wouldn't want to be rolled out of order in raising a new item, excuse me, because it hadn't previously been presented to the executive director or the chair.
Correct. That would be really trumping, I don't know, not even good form over, I mean, that would be trumping bad form over good substance. That does not make any sense. So I don't know why we would do that, read it that way. I think next is
Wait,
Jim?
Seymour, oh, I'm sorry, go ahead.
Yeah,
Well, I had raised an issue. I had sort of been looking at it from a different perspective that, not that it's happened, but what if the executive director and the chair were in conflict about a new item? And should it be the executive director versus the chair? But obviously the executive director should set the agenda because the executive director knows when staff is ready to present reports and things like that. But in terms of a new item and what would happen if a new item kept not appearing on an agenda and the members sort of didn't know why. But I think then after I made the comment, I realized that I thought about the new business issue and wondered, so now that I understand how those things work together, I think I'm fine with the way it is with Dolly's addition, because that sort of marries the two things together. So that's all I wanted to say. I think that works for me and addresses my issue as well.
Thank you. Seymour? Commissioner James or Chair James?
So I'm comfortable with the language. I think it's, and particularly as someone mentioned earlier, for new members coming on, having an informal process where people can speak to the chair, the executive director is fine, but I think it's encouraging to actually have it in writing that you may propose an item for the agenda by letting them know. And I think if it's not accepted by the chair and the executive director, it always, with the language that we've added or that we're proposing to add, it could be brought up as an item for new business at the end of the meeting.
Thank
Ava
you.
has her hand.
And Ava?
Thanks. I agree with Seymour. I think it's useful to clarify that for new members, and certainly the informal consultations can happen apart from that process as they should, and that would I expect to be the normal process. I just wanted to add that I think I'm comfortable with however folks want to do this, but in general, it's the chair who controls the agenda. New and other business is a required part of the agenda, so the chair doesn't have the power to avoid talking about something that a member wants to talk about, nor does the executive director. But to Jim's question about the chair and the executive director, I think obviously it needs to be the executive director who, as a practical matter, is putting the agenda together because we're requiring staff presentation. But the final decision should be the chair's, because that's what a chair is. That's sort of the point of the chair. So I would hope that that's always a consultation, but in some future executive commission that's falling apart and the chair and the executive director are at odds, I think that should be the outcome. Again, it should never come to that. But yeah, under Robert's rules, everybody has the power to raise something as a new agenda item. And if folks don't think it's ready to be discussed, a motion to table is in order and it can be raised and then punted by the rest of the commissioners, or it can be raised and the result can be, we need a report from staff on this, and staff says, okay, we'll get your report, and here's when we can, a member can't force this commission into a sort of filibuster situation using new and other business. because there are
Right.
procedures to deal with that as well.
If I may interrupt and sort of punctuate the point that Commissioner Ayers just made, yeah, during any business, when the agenda has not yet been approved, which presumably would happen at the onset of the meeting if there were any additional items that needed to be added, then it's subject to the introduction by motion of any commissioner, requires a second under Robert's rules, and then that motion is put to a vote by the commissioners. With respect to in a meeting, during a meeting, if any commissioner would like an additional item put on the agenda, placed on the agenda for discussion, that is subject to a motion by the full commission.
Thank you.
And I say that just to sort of qualify the sort of ultimate role that the presiding officer may have, namely the chair, in accepting a proffered additional agenda item.
Going back to your comment, Ava, is there a further revision you would suggest to reflect that observation, or do you think our existing practice where we are now at a time where we've had 3 chairs, and I'm not aware of any time where the collaboration between the chair and the executive director has not yielded the agenda.
Mhm.
So I understand that as a broad governance model, there might be certain expectations, but our experience with this framework of the 2 doing it in consultation, basically implicit in that is an understanding that in terms of policy matters and what's the priorities of the commission, the body, that's for the chair to articulate to the executive director. But in terms of the programmatic operational functioning of the agency, that's the prerogative of the executive director. And with both those 2 parties, the executive director understanding their relative role and the chair understanding their relative role, that leads to this, I think, in the 3 years we've been in existence, a pretty harmonious cooperation between the 2. And so I think if that's always understood, again, the relative roles, who's responsible for what, setting the broad policy is that the policy-making function is for the body. The executive director is implementing that policy and executing on it. So I don't know that we need further.
Yeah. Yeah, I wasn't actually proposing anything. I think the language as it's currently written is, I wouldn't have drafted it that way. I would have said the chair retains the authority to decide which meeting we're going to take up an item rather than the ED retains the authority, but I don't care.
Okay. Is there any further comment on this section? I'm sorry, Claudia?
I'm interested in knowing how Sandy feels about that.
Yeah, I prefer the language that we have, and in fact, I suggested it. I think it's the most efficient way to do it.
Can I?
In the time I've been in this position, I've never had a problem with that.
Can I solicit the opinion of the current chair and the former chair to see if they have any reason to be concerned about this language?
I'm not concerned. I think at least with my limited time as chair, Sandy and I have been able to agree on what should be on the agenda.
Thank you. And Commissioner Austin? Len, are you speaking? If you are, you're on mute.
Still on mute. No.
We're still not hearing you, Len, if you're speaking. If you hadn't been making
I was looking for my screen.
And did you find it?
Well, no, but I found the button that says unmute.
Okay, well, that's all you needed.
That's all I needed. All right, I'm loath to take any authority away from the chair in terms of the discretion of running a meeting. Otherwise, it just gets very, very sloppy and confusing. That said, I don't think this language really interferes with that, but there really has to be an understanding that the chair has some authority.
Yeah. Can I ask a question? Because I threw something out there that is reflective of my thinking, but I guess I should verify that it's shared by everybody. In that I said that as a broad governance proposition, the work of colleague, the agency, that there is the commission, the body that is responsible for setting policy, the broad policy-making function. And that is for the commission and to be articulated by the chair to the public and to the members of the staff. That said, there is the day-to-day implementation and administration of that policy and the running of the agency between meetings of the commission that is appropriately the role of the executive director and delegated to him by our resolution. So it seems to me, if we're all like-minded in that distinction, if future chairs understand their role that way, if it's understood that that's the executive director's prerogative, it seems to me that the two parties working together would know. If the chair said, after getting a sense of the body, that we want to implement policy A, but then the executive director, when that's being discussed, says, well, understand implementing policy A has all these administrative implications, and before we go much further, let's talk about that. It seems to me that kind of conversation happens if everybody is mindful of their respective role.
Dolly, and then Commissioner.
Okay. Commissioner Austin, did you have anything more to add? Because I feel like I might have cut you off.
No, I'm fine.
But I think then Commissioner Carb, Dolly has a question or a comment.
I may come back to you, but go ahead, Dolly.
I kind of agree with Ava and with Len that if you need to have that language, it should be reversed. Oh, unless you can make it a joint thing. I mean, yes, the commission. I mean, the chair and the executive officer have gotten along as long as I've been on this commission, but there might be a circumstance where that's not the case, and so I think that creates a conflict. So I agree with Ava and Len as to how that sentence should be switched. Thank you.
So you said it should be switched to say
the chair in consultation with the chief executive officer. Or the executive director. I'm sorry, the executive director. Changing your title.
Yeah, I understand.
But yeah.
I know we heard.
Unless we just don't have it because there shouldn't be I'm just concerned that, like I said, although everybody gets along now, there might be a situation where it's not quite that way. So I feel like yes. All right. Thank you. That's it.
It might be simpler that nothing will be added to the very simple. Nothing will be added to the agenda, which hasn't been presented at least 5 days earlier, similar to the 5 days for sending out the materials. And if anything new is to be added, the chair will rule on whether it should be on the agenda. And Robert's rules would say that's a ruling of the chair that requires a vote. And if anybody at new business wants to throw something on and appeal the ruling of the chair, you do that.
I think the point you're making goes to a slightly different issue, though. I thought Dolly's comment and Ava's comment was basically, who has the final say? Is it the way this is written, it says the ED in consultation with the chair, which arguably makes implicit maybe is that the ED is going to have the final say. And Ava, I thought, and Dolly were both making the point, no, that should be flipped. It should be the ultimate decision is that of the chair, but the chair is always mindful of the practical obligations that the ED is subject to. So if you flip it, again, if everybody has their relative roles in mind, it shouldn't be a problem. But so it seems, I don't see why writing it the way Dolly and Ava have, and Len has wanted to protect the prerogatives of the chair, which presumably the current chair does too, then flip it. Then flip it. Seymour, I'm told you have your hand up.
Yeah, after listening to the conversation, I think I do agree that we ought to flip the two. So, because ultimately the decision should be the chair's, but obviously any chair is going to consult with the executive director. So it should be the executive director in consultation, the chair in consultation with the executive director.
Okay. Is anyone other than, is any member?
I guess you don't want to hear from me on that.
Well, wait, I think we've heard from you, Sandy, and I think we know you.
Oh, I don't think you have. I think that's incorrect, but if you don't want to, then that's.
Let me be clear. I think you're in this meeting for a reason. You have a very specific role in the operate. You have the primary role in the operation of this entity. So yes, I think it's imperative that we hear from you.
All right, let me know when.
So, right now, if you'd like.
Now is good? Yeah, I mean, I think it's inconsistent with the provisions of Section 94. It's the role, it's the duty of the executive director to oversee the operation of the agency. As soon as we complete one commission meeting, it's the obligation of the executive director to continue the operation of the commission in accordance with policies established by the commission and to begin working on the next, up to the next commission meeting. And I think it's impractical, I'll leave it at that, impractical to think that it's possible for the chair, with all due respect, to be in a position to direct the agency toward the next meeting and to fashion the agenda. I just think it's unworkable. And the reason I had asked that it be structured the way it's currently drafted is precisely for that reason. Obviously, the executive director is not going to have the last word in what the agenda ultimately will be. And that is something that I, at least in my role with the prior commission and this commission, have done in consultation with the chair. We also have a procedure in place for carrying over reporting on residual items, which are then taken into account. If we're going to flip it, and I'm going to wait for the chair then to present me with the agenda, at some point along the way for the next meeting and work toward it, that's a different kind of structure. And I think that's inconsistent with the provision of the executive law that provides for an executive director to direct the operations of the agency in accordance with the policies established by the commission.
Vice Chairman.
If I may put it another way.
Excuse me. And I think it's imposing a burden, frankly, on the chair that's impractical and unfair to the chair.
Can I,
If you want to put the chair in the position of being the executive director as well as the chair, I guess then
I,
it work. We could get an opinion on whether that's permissible under section 94, but I think that's, and if there's an issue that we've had with this, it hasn't been called to my attention, and maybe I've been insensitive to it. But I'm not aware of difficulty we've had with putting together the agenda for any meeting.
there are three people that I've seen. The first was Commissioner Edwards. Then I thought Commissioner Karras had raised his hand. Is that right, Jim?
We also have Vice Chair, Chair, and Commissioner Olson.
Okay, okay. So can I take people a little bit out of order, because I'm told that we have both the chair, the vice chair, and the previous chair all who want to speak. And not to disrespect any of the other members who want to speak, but I think those that have some experience with the process could enlighten all of us. So could I start with the current chair first?
Okay, all right, thanks, Nancy. My suggestion for flipping it was only with respect to B. I believe that the exec director is responsible for preparing the agenda for the meeting, but if someone wants to add something, I think the ultimate decision would be with the chair under item B. So I would only flip those, the chair and the executive director in item B.
I think your observation about the distinction between paragraph A and paragraph B is essential, and I think that addresses some of the concern I've just heard from the executive director. But before I go back to him, or before I go to the others, Sandy, could I go back to you now and ask if what the Chair James just said, does that alleviate your concern somewhat? Noting that the act of preparation remains primarily for the executive director, but deciding whether or not an item's on there, the discretion, the ultimate final authority lies with the chair.
With respect to that, I mean, that in effect reflects the reality.
That's right.
I mean, ultimately, at the end of the day, the drafts are prepared, and I discuss it with the chair. Ultimately, collaborative decision, but
so if that interpretation
chair decides
reflects the reality,
they're removed.
Right.
So
if that interpretation, that reading of these two sentences together reflects the reality and accommodates the concerns that have been raised, does there continue to be an issue?
Only in B.
No, B would be flipped so that it would say relative to the, B is about who has the authority to decide what's added to the agenda. Then it gets flipped to say it's the chair in consultation with the executive director that's going to say what's on it. The chair's going to start out the process that has existed to date and of necessity, as Sandy described it. You have a meeting, Sandy knows what's going on every day. He knows what's following, he's sitting through the meetings, he's putting together the next agenda. That's what A is all about. And he'll talk to the chair about how to do it. But when you get to the point where there can be this issue about what's going to finally be on the agenda, that gets discussed in paragraph B, particularly when somebody's wants to add something to it, it's the chair that gets to make the decision.
So it's flipped.
I would suggest that the earlier in the clause, in the prior clause, the and or be in the conjunctive, but not in the alternative.
Oh, okay. This is, what?
I think it's imperative that the chair and the executive, so that the executive can inform the chair, whether it's in consultation, whatever the
Okay.
think both-
Is there anyone out there who I have not called on that had previously raised their hand, who has a suggestion that might kind of speak directly to this conundrum right now? I don't see any hands. Emily, you're good at seeing hands.
Ava, you muted.
Well, yeah, I had a
Chair,
proposal, but
or
um,
Commissioner
Oh,
Austin.
Ava, did you have something?
my proposal was just that, and I don't know how to word this exactly, but my sense is the current practice is the executive director puts together the agenda and the chair approves it before it becomes the actual agenda, which I think is consistent with the Executive Law 94, because under Executive Law 94, it's the chair who actually calls the meeting, right? Like, so it's pretty clear that the authority over the meeting in the final analysis is with the chair, but of course, at an implementation level, it's the staff who are putting together the agenda and planning the meeting and all that stuff. So I wonder if we can I mean, I think the wording of B as proposed to flip is fine, but I wonder if it would make people more comfortable if we just said the executive director prepares the approval and the chair prepares the agenda and the chair has to approve it before it's final.
Works for me.
Commissioner Austin has his hand up.
Commissioner Austin?
All right, first of all, getting down to the nitty gritty at B, it should be by notifying the chair and the executive director.
Yep,
It should not be one or the other. Two,
got it, okay.
Ava hit it right on the head. The chair runs the meeting. The executive director prepares as part of his responsibilities a listing of what his perspective is from the staff as to what has to be heard and dealt with to enable the staff to do its job. The chair has to be conscious of and sensitive to what the needs of the staff are. So if somebody suggests we do X and the chair speaks to Sandy and Sandy says, listen, the I&E department is just overloaded for the moment. We can't do it this month. Let's speak to the person who recommended it and offer to put it on for the next meeting so that the staff won't be so burdened or can segue into it much more easily. So I'm very comfortable with A remaining the same. I'm sorry, was it A or B? Remaining the same so that the executive director can give guidance as to what and where the staff is, and the chair can make a reasoned decision with regard to what has to be done. So I think the way this is written is right. With that one suggested
Wait,
change.
you mean the way Seymour suggested flipping it is right?
No, Seymour suggested making it, what am I, oh, there it is.
Can I suggest, I think, well, I think this is an important topic because it goes to, you know, the operational structure of how we operate. I think we're taking an extraordinary amount of time on this limited item, and I would think offline, we basically have the full commission membership listening to this discussion right now. It seems to me, I think there's enough of an understanding of what the concerns are, and there's different approaches for how to craft something that meets the needs of everyone. Could I suggest, because I know Mr. Ayers has been offered to be the scribe for this, but if offline, the two of us just try to work through something that works, and that a document that will be presented to at the next commission meeting will reflect that, but before it gets there, it would be circulated again so that no one was surprised. Is that acceptable to everyone?
No. No,
That's fine. May I just
Well, it
throw
is
in
waiting
one?
to say something.
no. I have a comment. Before you
sorry.
say that. I don't necessarily agree with that. I think that we need to resolve whether or not the chair has jurisdiction over the executive director to approve to approve the agenda. We need to
I
agree
think,
on. My,
I think, I thought there was an agreement on that.
well, what I heard Len say something different. I think he
You
said
heard-
something. What I'm suggesting is I like Ava's point that the chair runs the commission meeting. And he or she should approve the final agenda. It's not taking anything away from the executive director. They present it.
Correct.
In this case, he presents it. They discuss it in collaboration, but the chair ultimately approves the final agenda. That language would work for me. If we agree on that, then I agree with an offline conversation regarding putting it in writing.
Without getting bogged down in the specific words to be used, can we agree in concept that relative to a meeting, it's the executive director who either drafts or prepares the agenda? I don't care what the verb is, but that's the role of the executive director because he knows what's going on. Before the draft becomes the agenda for the meeting that will be chaired by the chair will approve the agenda. That seems to me to be what we've all agreed upon, and we just have to write it that way. Is there anyone who disagrees with that? Hearing no disagreement, Ava, is there disagreement?
No, I just want to underscore, if I may, just so it's clear. Sandy has been incredible in terms of hearing when I was chair, what I thought should be in, and it went in. It wasn't an issue. It wasn't a debate. The order in which things were done were discussed, and the chair really did do the agendas.
I thank you for that, Lynn. I want to be clear to anybody listening to this conversation. Nothing we are saying here, or at least nothing I'm saying here, is to in any way suggest that our executive director has not been faithful and diligent in preparing an agenda that the commission is expecting. So, and it's worked well, I believe, in 3.5 years, whatever, as a collaboration between the chair and the executive director. So if anybody really, this is really for the public. I don't want anyone who's in the public to take away anything other than that it's worked well. We are just trying to memorialize the process. So, can I revise? And Ava, I don't see you on the screen right now.
I'm here.
She's there. Only because I want to see your face as I say this. Could I revise my earlier suggestion and ask you on your own to try to craft that?
I've already done, and I don't think it's that hard.
I didn't either, but you know what?
Yep.
I'm
Happy to do it.
Thank you. Okay.
I'll share this after the meeting. Thank you.
Thank you. Are we ready to move on? Are there any comments about the supporting materials? The real change that I think has largely started to become the practice is that when we get our commission books, that the materials we receive, if there's an item we are to act on, it is helpful, I think, we have found, the members of the commission, if the materials in the book contain the necessary background information to bring us all up to speed, to understand the thinking that's gone into the staff work that has produced a document. We are not asking for every single thing a person thought. It's, in any of us who've worked in organizations where you have to write a memo for your boss, your boss doesn't want to hear every single thought you ever had, but they want a succinct statement of what you have. And that's all we're trying to get. So that if there's relevant information, we need to know if there's a relevant authority or anything like that, we get it in advance. That's what this is trying to say. I know in conversations with the executive director, he wants to keep it concise and brief or whatever. Obviously, we all appreciate and benefit from concise information. The question is not whether it's concise. The primary question is it complete? That's what this language under supporting materials, particularly in paragraph 2B, was trying to get at.
I'm
Any
sorry, did
concern?
we, I apologize. So we finished now with, section 1, agenda preparation, because does everyone?
Was there any other concerns about the agenda preparation? I didn't.
Well, I just wanted to suggest, I guess everyone's in agreement with the suggested timeframes. I had initially asked that be removed, but I'm agreeable to it staying in if everyone else is in agreement with it. And I just wanted to change the language in section E to say, absent and urgent, unexpected occurrence, the agenda and all supporting materials, which is, I think, what Claudia was suggesting, but it's not necessary, but it's my suggestion. That's
Thank you,
on
Dolly.
1E.
Yes, I think, does anybody, I can't,
No hands are up.
no hands are up. Okay. The reason for putting a time frame in there was it's just a good.
I understand that. I do understand that. I just
Discipline
wanted to.
ourselves, but obviously it's just a guide.
Okay.
But it is problematic though, when we get, things sent to us via email after the book is out that we have to read very quickly. And I just think that for me, that's problematic. It gets done, but I don't always give it a chance.
You're going on to paragraph E, and I agree. I think if that needs to be clarified, obviously there's a challenge, I think, for the staff that they make every effort to get everything to us in the book to us by no later than the Friday before our Wednesday meeting. But I understand too that the world keeps moving between when the book's put together and when we get there. And there are times, and it seems there are many times, where something else comes up and it's sent to us. Other than to know that's, I hope it's because it's unavoidable. It's not because staff were tardy. It was that it wasn't done. It wasn't whatever right for the book yet. But I think the problem that a lot of us have is that we tend to get things sent to us in a variety of different emails and the like. And then when we get to the meeting, it's not always, there's different pieces of paper that have come at different times. And the question is, does everyone have everything that is now part of the agenda and the materials with it in front of him or her as the discussion begins, as opposed to saying that went out separately and the like? I think there are two issues there. One is the timing, and two, trying to find what's been sent. Is that a fair statement of the concern, Claudia?
I just think that if we're going to have a policy, it feels like it's practice. I know that, staff does its best, do their best, and I sympathize with that. But it's now practice. It's just understood. I have to check my emails to see all the updates. Then I have to catch up with the hard copies of the existing material that was sent, or new material that I have to now read and figure out what's appropriate for the agenda. So my question is this section E, is it an attempt to eliminate that? Because if it is, it doesn't. If we want to continue that practice, fine, because of circumstances. I mean, that's fine. I'm just saying it becomes difficult for us to read multiple things. I'm reading one version and everybody else is reading something else. And if we're gonna get it 5 days in advance, then give it to me 5 days in advance. If it's gotta be 2 days in advance, give it to me 2 days in advance. But giving it to me the day of the meeting or at the meeting, it just doesn't work. That's all I'm saying. And then we have a ton of questions. We waste a lot of time at the meetings focusing on that and not with the staff intents.
Thank you. Seymour, did you have your hand up? Or,
Yeah, yes, I do.
and then,
I just want to suggest, oh, sorry, go ahead.
no, Seymour?
I just want to suggest that maybe you take portion, I guess, section 4, a segment of 2B and add it after E and under agenda preparation. So we were saying if something arises, something with immediate action arises after the agenda and meeting have been provided, revised agenda will be sent out. And then we can talk about the supporting materials in 2. But just adding to 1 so that it's clear that if something comes up, notwithstanding, Claudia's concern, I think if something is urgent, then we do have to include it, and we can put it in the agenda preparation. Did I make myself clear?
So I didn't quite follow that, Seymour.
I guess
Just
what I'm saying is we talk about in section 2 the supporting materials and that they will be sent out. If something comes up, they'll be sent out with a revised agenda, saying we need to include that revised agenda portion under 1, the agenda preparation, and then talk about the supporting materials.
So would that be just moving 2B to become 1F?
A part of 2B to be 1F, yes.
Which
The
part?
part about the agenda, rather than, because the section
Right.
1's about agenda and section B is about supporting material. So
Okay, I get it now. Thank you. I can do that.
I think that, but I think there might be two causes for the sources of concern for what Claudia was talking about. There are materials that come from the staff through the executive director prior to the meeting, but there also tends to be materials that come from other commissioners who have reviewed the materials once they get them, and they see things and they comment on things, and some people go so far as to revise things, and they get sent out as thoughts for consideration. Yeah, that's it. Is that how, do people agree that there are two sources of documents coming to us sometimes, some from staff and some from other members? And I think that just amplifies the amount of work, Commissioner Edwards is work and confusion that Commissioner Edwards is describing.
There's, if I may, there's also a third source, which are instances where commissioners review the materials and then have questions that they ask staff to address. For example, in the last meeting, a request was made to recirculate a memo that had been provided to the commission a couple of years ago, addressing some issues, so that came out. So that was provided by staff. And then we have instances in which new business arises, an application comes in that needs to be addressed relatively quickly by commissioners. And it may be coming in on the eve of the meeting. So it can be that, hours before the meeting takes place, we're supplementing the record. So those things do occur.
Do you want it to occur?
Well, we want to keep the business moving, and we're trying to be very responsive to our interested communities and constituencies and to the commissioner's needs. And so, staff is extremely flexible when it comes to those. We recognize it does create a burden. And then we'll have the additional requirement of preparing memoranda. And I did provide samples of what those memoranda might look like for the most recent agenda book. I don't know if those were helpful or not. I hope they were. That's what we're thinking of. But that will also add a little bit of time. If we get a last minute item, I can foresee it didn't happen this time, those trailing. So an item might be in the book, and it might be, we need some additional time to prepare the cover memorandum for the item. And I would anticipate there will be instances where those will be coming late as well. So there's up to 4 or 5 instances in which the book that you get, and maybe even the agenda that you get 5 days before or 6 days, which is what we're striving for, ultimately is not the final set of materials and final agenda for the meeting.
Can I speak?
Yes,
Yes.
Claudia.
Thinking, well, maybe there should be more discretion about what you decide regarding you send us. Like, for example, the memorandum that you mentioned we were asking for. I think that particularly came from the chair of the admin committee as material that we needed to have future discussion. That might not have been necessary to give to everyone at the meeting, but to give to the chair of administration who requested it to do it at another point. I'm just saying, only material that we need to see at the current meeting should be additional materials that you send. That must be addressed at that particular meeting. And I'm just wondering, how do you handle staff who comes back, not staff, commissioners who come back with revisions for an existing meeting? Is that proper? For me, that feels problematic.
We scramble to be responsive, and if the response means assisting in circulating additional materials or preparing additional materials on the eve of the meeting, we strive to do that.
But the bottom line is, I'm not going to read that before the meeting. If you give it to me, if I get it at the meeting, I come to the meeting a half an hour early. I'm not going to read it with any real understanding. It's too premature. It's too early. It's too soon. So why? I mean, I don't know what to do with it. I understand what you're saying, but the question is, to me, that bogs down the meeting. It raises questions and it takes us on tangents sometimes.
Yeah, and that's the problem. I guess that's the flip side of staff trying to be as responsive and complete and as accountable as possible. So if we're asked by a commissioner raises a question after reviewing the book, inevitably on the eve of the meeting, we're going to do our best to respond to that. And if we can respond to it in writing and circulate something in advance, my goal is to do that, as opposed to presenting the response as, orally at the meeting. We're trying to get through the agenda. I'm come all the way back to the agenda preparation. Our goal is to get through the agenda. If we have an item on the agenda, it's because the executive director and the chair, in consultation with other recommendations from other commissioners, have decided that these are the items that we need to address at the meeting, or ideally should be addressing, and not allowing to linger or kick down the road. And so if that means supplementing the record in an effort to answer all questions that are coming up or may come up, we're going to do that. And I recognize that does present a challenge. But the goal continues to be to ensure the commissioners have all the information we can provide to them for the items that are on the agenda. And it does happen, not infrequently, that matters are sent to a committee or they're deferred to the next meeting. But it's I think it's unavoidable unless we're going to just say 5 days is the cutoff. That's it. If the materials aren't there, we'll just have to get by without it. That takes pressure off staff. But we can just draw a line and say, we'll discuss it for the next meeting. I'm very reluctant to do that, but we could have a hard and fast rule like that. And then there is the other category of things that come to us that have some urgency. And it's just, they come after the book is done. And they're essentially new business items that do come up.
I believe the chair had his hand up, and I guess it came down, but the vice chair has her hand up, or had her hand up. Is that right?
She's muted. Vice Chair, you're muted.
I'm sorry. I forget I have to take my hand down and unmute myself. Yeah, I just wanted to say, I think the solution to this is in the motion to table. in that if I think that the dilemma is inevitable because we're going to have complicated things on our agenda and some members are going to have questions about them. And staff does an admirable job of scrambling to answer those questions. And I think it's very hard to make a hard and fast rule because sometimes, like, I have a question and none of the other commissioners do. And to answer my question, Sandy will magically pull up a document that none of the rest of us could have found. And of course, wanting to not exclude anybody from the conversation will CC everybody on that. But nobody else cares because it's just my weird little pet peeve and staff is being gracious in responding to it. Okay, in that situation, we should not postpone the vote because I'm satisfied. I got my thing. Nobody else was interested in my question and we could move on. In other situations, we're getting like a revision in the draft that we're being asked to vote on. And it's the morning of, and people feel like I really can't vote on that. Then I think the solution is make a motion to table so that we say, look, we've now reached the point where we're doing too much editing or too much changing or too much substantive discussion by email the night before. Not all members can be part of that. I think it'd be appropriate in that situation for the chair to just move it to the next meeting, which I think is consistent with the chair's power. I think it's also okay for any member to make a motion to say, listen, I haven't had time to review these materials and think about them. So we should move it. And I think we should all, maybe we should incorporate that into this draft so that members feel validated in that and comfortable that we do need everybody to be fully informed before they vote. Even if there's already a majority, it's everybody's responsibility on this commission to fully inform themselves and vote the way they do. So I wonder if it would satisfy the concern to say, if comments and responses to questions have been circulating without much time before the meeting, any member can move to table to ensure that all members have a fair opportunity to review the materials. I think that's implicit in Robert's rules, but again, recognizing this document will be used by new members to figure out how to do things, I think it's helpful to spell it out. But as far as I can see, that's the only real way to solve this problem because I don't think any bright line rule is going to make sense.
I think Ava's point is well taken, and I would submit too, when we sometimes get materials from other commissioners at the last minute, it's kind of by definition, if the materials are, if a member or a group of members took time to think about something after they saw the book, and they take the time to put something in writing, it almost by definition suggests on its face that it's not ready for discussion. And so, as Commissioner Ayers says, what you do then is you table it. So if we want to add that proviso into this section, does that address your concern, Claudia?
It would.
Was that a yes? Is there anybody who has a continuing issue? Sandy.
Yeah, no, it's not an issue, just an observation. In some instances, new drafts are being provided, red lines from commissioners or from staff, if something new has come up or a question's been raised. There are other instances where commissioners have put their thoughts that they would otherwise be presenting during the discussion of an item, they put it in writing for the benefit of everybody. And it would be a shame if that precipitated a tabling of an item because folks didn't have time to read it. So, you know, we want to be able to be somewhat able to distinguish those kinds of situations from instances in which, as Commissioner Groenewegen has said, maybe an item's not ready for. This is just an observation on it.
I would submit that if you implement the suggestion made by Commissioner Ayers that in the circumstance, a motion to table is appropriate for the member who feels that they're not prepared because of what they've got. But it seems to me the practice would be to debate the motion. And if on debate of the motion says, but it's really just a comment, it's not a whole new draft, then the motion to table might fail if it were that circumstance you just described, Sandy. But if it's the circumstance where you get a new draft of a document and people just haven't had a chance to think it through, then the motion to table would likely pass. So it seems to me, your concern, I think, could be addressed by the discussion had around the motion to table to take account of the specific circumstances.
Sure.
Yes?
Great.
Okay, so with that, can I go back to our volunteer scribe and master record keeper and note taker?
Yep, I'm on it.
Great. You know, it's great to have an academic on the commission who wants to. Okay, so.
Not all academics enjoy bylaws the way I do, but yeah, there we are.
You know, you're just one of those girls, you know, it makes you happy. Bylaws. Okay, so are we done with supporting materials?
We're not done with agency agenda preparation.
Wait a minute.
I have an item that I don't want us to gloss over, and I think we have accidentally. But section 4, subdivision 1, agenda preparation, item or letter E.
Yeah,
We're still on E.
yeah.
I want to make sure that everyone is aware of the fact that when you require the agenda and supporting materials to be provided to the members at least 5 business days in advance of a meeting, that's different from 5 calendar days.
Yes.
It's a very important
Yes.
distinction and difference, and I know dear to some of the commissioners
Okay,
in this video conference right now. If we stick to 5 business days, the meeting, our book day will need to be earlier than it currently is.
I think, my bad, take that out.
All right, so what are we talking, 5 business days or
Calendar.
5 calendar days?
Calendar.
Okay,
The status quo works.
okay.
I agree. It doesn't it for most people? We get our books on.
Well,
Well,
I
they
don't
go,
know what it looks
they go
like.
out
Ask
on
Commissioner Edwards.
Thursday and we get them in the mail on Friday, correct?
But-
We are aiming to get them out the Wednesday before the meeting occasionally. We do it on Thursday instead, whether because particular matters aren't ready or gathering data or for whatever reason. But not
Every committee.
the goal for the commissioners to have ideally the books by Thursday overnight, but no later than Friday before the weekend.
Yeah, and maybe we shouldn't say this in an open session, but I would be prepared to bet that many of us read our books much closer to the meeting than that.
So it's fresh in your mind.
So it's fresh in our mind, that's right. So, yes.
Commissioner Austin has his hand.
Yes, Commissioner Austin.
Commissioner Austin, you are muted.
As
It's the
usual.
same button we pushed last time.
Same button. Might I suggest that what we say is that make it 2 or 3 business days after receipt of the book. And that way we have a guideline. We look a little earlier if we can, and that way if there's a suggestion that we at least have time to see it and deal with it. That would be like a lead balloon.
No, I think you're making us count and vision calendars.
So right now, the language says will be.
Yes, Seymour, yes.
I think the current practice is, I guess, we never get it later than 5 calendar days before the meeting.
Correct.
Why don't we just leave it at the
No,
5
but-
calendar days? And efforts to get it to us earlier are much appreciated.
Yes, I think that's great. That's why I was saying strike the, I
Business.
think I'm the one who stuck in business. It's mea culpa. So just go back to calendar days. Yes.
Sounds good to me.
Okay. Keith, are you satisfied?
Yes.
I think the chair. I think
As long
the chair
as
has
you
his hand
are.
up.
Step.
Seymour, do you have your chair? Your chair. Have your hand
We're comfortable with 5 business days.
I failed to lower my hand, sorry.
up? Okay, thank you. So yes, it's back to 5 calendar days. Okay,
calendar days
can
it
we
is.
move? What was that, Edgar?
Oh, I just said 5 calendar days it is.
Okay, great. I think we're done with the supporting material stuff, right?
Yes.
Okay. Executive session, I think.
But before that, Commissioner, just with respect to the cover memos that are being requested, I did again in anticipation of this discussion, provide samples when you had prepared, Commissioner, for the meeting rules. Are those coordinate with what we have in mind for the cover memos?
Is it in this package?
And if they were in the last agenda book for the June meeting.
Oh, the last.
Like, no, I think they were generally good, but I think that there is no magic. This is hard for me to describe because it's kind of the way I've always worked and I'm used to working, is that when you're preparing something, a document for somebody to read and act on, and they haven't seen it before, there should be enough information to tell them what they have, why they have it, and what they're expected to do with it. And the why they have it will often include all the relevant facts. All I can say is, in my experience, we tend to get memos often from the lobbying group that explain to us what we're getting, and that typically has the level of detail or explanation or background that I need. So if you're looking for a good model, in my experience, but I would defer to others, I think those memos are generally very well done. Anybody got a comment?
Yeah, I got just one if I could add. So I just wanted to say, for me, 99% of the time, all I would need the cover memo to say is that this comes from staff and we're asking you to vote to adopt it. Like I just want to know who the source of the document is, because if it comes from staff, that's different than if it comes from a commissioner who just asked that it be put in there. And then I also want to know, is this for discussion? Are we being asked for initial feedback? Is this just an FYI to brief us? Or are we being asked to vote? And if so, what motion would staff like a commissioner to propose? And so the lobbying memos are great. I don't mean to say that they're too long, because they're incredibly helpful, but most of the time I don't need that. Like if it's a resolution, you don't need to say the reason we want you to adopt this resolution is that we think it's a good resolution. Like just say we're proposing it for adopting, but then sometimes maybe there is more that's needed.
I get, but that's what I'm saying. I think it's kind of a common sense case by case thing. Like if it's a resolution and we've been talking about it, people know what it is. But let's say there was a time where when we first saw the request to deal with the situation where we learned that there were a number of agencies out there that had challenges meeting the training requirements, and that prompted a request. That requested had come for waivers or extensions like. And then I don't remember there being, maybe this is just me, but I don't remember there being a lot of discussion about that before we were presented with a draft. I think the first thing we saw was an advisory opinion but whatever it was, I opened my book and I saw this thing and I said, where did this come from? And when we got to the meeting, as I recall, we heard that we received these requests from a couple of entities. I remember we asked, could we see those requests? Because we needed to put it over to the next meeting. And it seems to me, I think we could have been more efficient if, when we got the initial document we were being asked to look at, we had said, some agents, you're going to be asked to approve this draft request, this draft policy. It turns out we did it as regs, whatever. But you're being asked to consider this. The reason is background. Some agencies have problems resource-wise, dealing with the mandate. We've received requests from them, see attached. This is designed to address that. It's not a long memo, but it tells me enough that you guys who are living the reality of managing the agency day to day, all this stuff is going on that you're not telling us about every single time, but it's happening. We've thought about how we want to deal with it. And here's the background. So I would see like a 3 or 4 short paragraph summary, a document, and the supporting document, so I understand where the requests are coming from. That's an example. So, Claudia?
Another example, in terms of format, I like to have the context within which I'm looking at something. So I would be a little bit more like, what is it that's coming before me? Who's presenting it? What action is being required? Is it a vote? Am I supposed to review it? Is it going to be discussion? What are the implications if it's approved, the policy implications and the practical implications?
Does that help, Sandy? To define.
I think we'll have to work our way through it because it will affect the workflow if if we're preparing a white paper for an item, and if that's what some commissioners will be expecting, then we'll have to work that into the workflow. If it's an explanation of the action sought, and if we can have a discussion and respond to any questions commissioners have beyond that has a different impact on the workflow.
I don't think there's ever been a suggestion for a white paper, but maybe I define a white paper differently.
Well, background, legal analysis, implications going forward. It could be, depends on detail analysis.
No, this is kind of like, brief, think of it more as in the world of documents you're asked to prepare in life. It seems some people, there are talking points, there are white papers, there are comprehensive legal analysis. There's a whole bunch of different things, but it seems to me, and maybe my experience is just different, but it seems to me there are enough talking points that don't have to get into all the policy implications of what we're being asked to think about. That we'll discuss in the meeting, but to tell us how the issue came up, and I mean, just use the example I gave you. Maybe I'm remembering it wrong, but it seems to me, I wasn't aware that some agencies had asked for waivers and extensions on the training requirement. I just didn't know that. And yet, so staff knew that it happened. Staff is dutifully working on it. And staff comes up with a solution, a proposal to deal with it. And the way that came to us, as I recall, was that the first document we got was the solution to the problem or the concern that I was learning about for the first time. So I'm reading this document, and all I would have benefited from was, you don't have to tell me the whole history of the training. You just have to tell me some agencies, because of how they operate, have real problems. Staff don't have computers, they have whatever, blah, blah. We've written that a million times. A number of agencies have requested waivers and extension. Sentence. The law allows us to, or whatever it said about waivers and extensions. This is our proposal to respond to that. I think 4 sentences of that level of specificity would have improved the discussion of the process. But
No, I understand it. In that case, and I understand, we were asking for a delegation of that authority because the statute vested it in the commission and it wasn't clear. It was plainly something that could have been delegated to the executive director. And I understand we're planning to do that.
That
Because it's
came
not-
later in the process, though.
Right.
The delegation discussion came later in the process. If you go way back to the beginning, 2 or 3 meetings back, was when we first were presented with that issue. That's all I'm saying.
Well, yeah, my question is that,
Can I stop this conversation? Because if everybody else who's a member is saying, Nancy, I don't remember it that way, and give it up, girl, I will. But if I'm by myself, tell me, because I don't want to make a problem that nobody else has.
no. My real question is, I endeavored for the June meeting, for the action items we had, we did have a little cover memo for each of those action items. And if those were in the realm of what commissioners will find satisfactory, then I have that model and we'll use it going forward. So maybe what we need to do, just let me know, take another look. We'll be doing the same thing, but we don't have another meeting until the 23rd. Take a look at those. There are 3 of them, and if those are satisfactory, then we'll know directionally what commissioners. If there's something else, let me know.
It should never be more than a page, even a half
Yeah,
page.
these are all quite concise, and one may have gone up.
Ava?
Yeah, I just wanted to say, in light of this discussion, I think I can revise this a little bit to be a little bit more specific and helpful. I'll do that. But basically, I think, yeah, Sandy, I think that the memos you've been doing are in the right direction. For me, it's 4 things. It's identify the author. It can be just staff, but we should know whether it comes from staff or somebody else. Identify the action sought from the commission, like what are we going to vote or not vote, and if so, what are we voting on? Identify the one that I think is really important is identify any previous version of these materials that have been presented to the commission, so that if we did discuss it before, we can go back and like review the minutes from that conversation or whatever. And then I think just explaining any necessary context. So I don't think there's any better way to formulate that than just saying if there's context that we need to take a fully informed vote, then we should have that context so we can think about it before the meeting. And Nancy, I feel like that covers your the case that you're talking about, but that's my thought.
Yes, and I think all those elements were in the draft as it was. They're just different places, but yes, that's what we're trying. So, but if we want to massage it to get it all in one place, that's better. And if, as Sandy just said, as we go along, if we're finding we need more, we'll tell you. But if we're getting it, all's the better. This is part of making our meetings more efficient. So are we done with supporting materials? 2 hours on? Okay, good. Yes, Claudia?
I just point out that I included some comments on supporting documents, which I won't discuss at this meeting. But you can take it into consideration.
Thank you. This discussion in about executive session, I do think there's a legal issue out there where staff has given an opinion, and if we could take that up in executive session, that would be great. The next thing about the minutes, again, there was a discussion had at one point to try to simplify our minute taking or to make it less sometimes the minutes tend to get very factual to the degree of almost looking a bit on some discussions like a near verbatim recitation. Other times it's just a more global discussion. And so the recommendation that is embedded in this document is to, on all matters, report only that which the open meetings laws requires, the votes taken and the like. But when there are discussions where there might not necessarily be a vote or there is a important discussion, rather than try to leave it to somebody to subjectively edit and incorporate into the minutes the discussion, we can take advantage of the fact that the meetings are video conference, the recording is kept, and there are timestamps so that we can find we and the public and anybody else who wants to know what was actually said can have the benefit of the actual discussion, not a subjective summary of the discussion. That's what this is trying to say in section 6, paragraph 1. Thoughts, concerns, considerations, objections?
Commissioner Austin has his hand.
Oh, yes, Commissioner Austin.
I think the minutes are much too detailed. It's almost to the point that the minutes would reflect that I just cleared my throat. Although I did have to clear my throat. I think a much more simple overview of what happened, what the general idea of what we discussed, what we decided, and done.
Would this be something different? Would you do something different than what is proposed in this draft?
I think, excuse me, I think it needs to be clearer that, excuse me, it just needs to be clear that it doesn't need the precision and exactitude that we have in there. That's first of all. And second of all, do we really even need a statement as to that, or just whoever the scrivener of our minutes should be told to take it easy? Need that officially?
I think this is helpful for that person.
I guess I would want to hear from the staff here who are responsible or involved in the preparation of the minutes to see if there's value in having some kind of guidepost in the document. But who does? I mean, I know in the end the minutes are reviewed by the council and the deputy council and the executive director, but who else is involved in the preparation?
Aitana and Martha, they're the ones taking notes, right?
Correct. And then the council's office edits those first drafts of the public and executive sessions of the commission's meetings.
So to Commissioner Austin's point, would it be the real discretionary function lies with the editing? And if I'm understanding it right, that's where you got to figure out what stays and what goes, or what can be condensed or summarized. Is it
Well, it's more than the editing, I might suggest, because even at the very first level, i.e. the drafting, the scribing, the scriveners, so to speak, as you've referenced them, Kitana and Martha and Sarah would be well served if they knew in advance that they did not have to strive to effectively narrate the substance of any commission meeting. Right now, I don't know that they're under that impression. So I don't know that it requires a rule. I don't know that it requires, a writing in black and white to convey that message to them. I think there are alternative ways of sending them that message. But it really does start at the very beginning, when the folks who take the notes now have to figure out how much of the content of those notes and the content from the audio recording needs to be captured in the minutes.
It seems to be to any person responsible for keeping minutes in accord with the open meetings law, it's helpful to start with what the law requires, which is very little.
Correct.
And so it seems you know what the bare minimum is. It's that flavor, the summation of the distillation of any meaningful discussion, as opposed to the back. And that's a judgment call.
Correct.
And that, you know, so it seems to me you've got to understand what's required, and then the person who's, it's not a typing function, it's a discretion. What am I gonna
Right.
include and how am I gonna summarize it? If the best way to accomplish this is to just not say anything in here, but go back or modify this to just remind whoever has to do it. But it's not the people that are typing the initial draft.
But they need guardrails. They need direction.
But I guess that direction doesn't have to come from this policy, maybe. That
No,
direction
correct,
comes
correct.
from the
That's what I'm
town.
saying.
Okay,
Correct. Yep.
so with that, are people fine on taking out everything other than leaving in the first sentence, the minutes, you know, is the record of all the votes taken. That's right out of the statute. Take the rest of that out. But leave it to, it say nothing else in this policy on that, knowing that we're leaving it to staff to work with the note takers and the editors to do what Commissioner Austin said. Our minutes are way, way, way too detailed and too long. And the essence of what we're doing gets lost.
Sorry, Nancy, just for my notes, are you proposing to delete just the second sentence of section 1?
That's my
Subsection
question.
I would delete it. It maybe if we could come up with a way to put one sentence back in, you know, discussions of matters. I was trying to get to the things where there's no vote that could be lost
Mhm.
completely in the minutes.
Mhm.
And you don't want
Yeah.
them lost. But you could say a concise summary of the discussion had, something like that, rather
I
than.
personally like it the way it is.
I
Yeah.
don't like that sentence. I do
He
not
does
like
not.
that sentence.
Okay, well, the council doesn't like the second sentence. And so the council who could have to defend our minutes, I would defer to. What would you like?
Well, as much as I don't like the second sentence, I think your sort of slight revision of it, did you just suggest a tightening of it?
Yeah, that it would include a concise summary of the discussion.
Yeah, I think that can be easily done, whether it requires, I can't think of the word immediately, but, you know, including sort of annotated time stamping.
You could put that in there.
I would not do
Okay,
that.
okay, then don't. But
That's a level of detail that I'm hearing objection to
you're hearing that objection to
time stamping, to have,
I thought the timestamp was intended to let somebody know if you wanted more,
Oh,
that's
I
where you
see.
find it.
I get
But,
Mhm.
no.
but
So no summary, but just the timestamp on where.
But I thought you were objecting to just the timestamp. I think a concise summary of the discussion that can be found at this timestamp.
I agree, yeah, I mean.
Can we agree to,
I think my notes do that, so I think it can be done.
okay, so, Ava, did you have a thought?
Nope.
Okay, so,
I think Sandy has his hand up.
Yeah, just a question. Would you be satisfied with something as concise as a discussion of the pros and cons of the proposal followed?
yes,
Yes.
I would agree.
That's the way it's done.
I would agree.
More texture than that.
No, that's
Yes,
great.
I think
Yeah, no
I
more,
think that works.
simple as that.
Yes,
Discussion ensued,
yes,
period.
that's fine, that's fine.
That's the way it's done.
Yeah, it could just be a discussion. Maybe it's just the pros.
Can I add just
A
one thought to
discussion
that after
ensued.
I'm?
I'm sorry, Eva.
Yeah.
Oh no, go ahead, Lynn. Go ahead. It's fine.
I was going to say, a discussion ensued. Commissioner Austin made a motion to approve the recommendation, seconded by, vote, done.
Yeah,
Yes.
Yep.
That's it.
I think we're talking about though when there is no vote taken, right?
Vice Chair.
and whether we need the, the timestamp, which I think would be helpful. So,
Well,
sorry, I interrupted you.
no, that you're not, Ava, did you raise your hand?
Yep.
Yep.
I was just going to say the only other thing, I think this all sounds great. The only thing I would add is I agree. I don't think there's any point in summarizing the discussion and who said what. The only thing I would add is when somebody commits to take an action, I think the minutes should also reflect that. So like if Ava said or Vice Chair Ayers said she would prepare a memo on the subject and circulate it to commissioners, I think that should be reflected as well. So formal actions, when there's no action taken, we can say a discussion was had, and then when somebody commits to do something, staff said they would prepare a memo, then that should also be there so we could memorialize the commitments that people make.
Well, one advantage of that approach was that would eliminate the need for the follow-up. The document that I create, that the outstanding matters. But I'm happy to keep doing it.
I think it's still helpful to me. The minutes are not exactly, yeah.
Better not to lose it. Okay, but I like, do people like what Commissioner Ayers' suggestion?
I'm for it.
Hearing no objection, seeing no hands raised, I think we're done with minutes. Two more things on this abstention. The only issue, there is an issue related to abstention. Commissioner Carvalho has raised it. The original draft had a requirement that a member who abstained state the reason they're abstaining. This is where my knowledge of parliamentary procedure, whatever's at work here, that it's limited may be a problem. But my understanding was a person was to abstain when they didn't have enough information to vote on the matter being voted on, as opposed to a person recusing themselves from a vote where they've got some conflict of interest or whatever, But I, in my mind, I was distinguishing abstention from recusal.
And there is a very big difference.
Right,
It's
and
often
we dealt with recusal.
inflated.
Right,
Yeah.
and we dealt with recusal in a different policy.
Mhm.
But here, and if my understanding of abstention is wrong, it seems if you're doing it because you don't have sufficient information, which everybody does when they weren't at the meeting, so they don't approve the minutes. But if there were another situation where a member was abstaining, you should be able to just say what information you don't have if it's not something as obvious as I wasn't at the meeting. I thought it should be understood that you would state why you were abstaining. And the reason I thought this was important when I drafted the original iteration was that our obligation as members is to vote when we're asked to vote. That's
Correct.
That's our duty.
Correct.
And it seems to
It's
me
your obligation.
that's right. And there may be times where, because we don't have enough information, or because we have a conflict of interest, if we don't have enough information, we can't vote. It just should. And if you have got and then you abstain. If you got a conflict of interest, then you recuse.
Correct.
But it seems that particularly in our current configuration, where we are down to 7 members as opposed to the 11 contemplated by the statute, and every vote needs at least 6. An abstention, it's huge. So that's why I thought the public was entitled to know why a member was not voting. So that's why I added it in. I thought it was part of transparency and our obligation as members.
And if I might again offer my opinion, I think that additional language may be helpful so as to make sure that no one is abstaining for the wrong reason. Again, the expectation is that every member votes when a vote is conducted. And it should only be for the reason that one feels themselves to be insufficiently informed for whatever reason, that they abstain. Otherwise, one should vote if they don't have a conflict of interest, which would otherwise require them to recuse rather than abstain. But abstaining just for the sake of not voting on something because there are other factors, external or internal, that are driving your decision-making, those should be avoided at every turn. So that only when you're feeling insufficiently informed that you resort to abstaining from a vote.
Okay, Dolly, did you want to speak to this? Because I know you.
Yeah, if you're only supposed to abstain because you don't have enough information, do you need to know why I don't have enough information? Or, I'm saying any commissioner. Do you need, I mean, what else do you need to know? I'm saying I don't have enough information to vote. I'm using myself or whoever it is. What else do you need to know? Do
Well,
you need me to
guess-
say I don't have enough information to vote? If I'm abstaining? Do you need to hear that at a meeting? Is that,
Well,
that's my question. Like,
I
it's
guess my
assumed.
question.
Yeah, I'm sorry, go ahead. It's assumed the only reason to, we all know the only reason to abstain is because you don't have enough information. So that's my question. What else do you need to know?
With all due respect, I don't think that assumption is a safe one. Because I've seen this borne out where that assumption is patently false. So I don't think that's an assumption that we can make, that everyone and anyone who abstains from a vote is doing so because they don't feel sufficiently informed. I don't know that that is a guaranteed a factor when someone abstains. So it would be nice, as I said earlier, to have that explanation placed on the record. So at the very least, we are sure that one is abstaining for the correct reason and not an incorrect reason. Or an inappropriate
So my question is, I'm sorry. Oh, go ahead, I'm sorry.
Still staying with your example, to the extent one doesn't feel sufficiently informed, it would then, once that is announced, it might then generate a way of identifying what additional information needs to be shared with the body so that everyone is sufficiently informed and on the same page. So to the extent you can explain what you don't have, it'll make it easier for staff or whomever to get you what you think you need in order to be sufficiently informed.
Ava?
Yeah, I just wanted to flesh out what Keith said. For me, it's not, lack of information isn't the only reason you would abstain. A good faith example of a different reason is, let's say the commission at some point in the future is asked to approve something that staff is doing, and a commissioner feels that we, the commissioners, should not be voting to approve this, that should be a delegated staff responsibility. So I object to this vote. I have a principled objection to the vote. I've been overridden, so the commission is nonetheless asking to approve it, but I think it's within my rights as a commissioner to abstain, saying this is not something that we should be asked to do.
I think you should just vote no. I firmly believe you should.
I couldn't hear you. I'm sorry, Keith. You should what?
I see. You should vote no.
Oh, vote no. Okay, right. That's
in that instance.
And is that, Keith, is that because an abstention has the same effect as a no vote in that it won't pass if it doesn't change the quorum needed to pass. Like, you still need 6 votes. So if I'm abstaining, I'm not contributing to the 6 votes. So I may as well vote no.
No, that's not what I'm grounding my opinion on. No.
But like, I don't want to be recorded, especially if we're doing concise minutes. Commissioner Ayers voted against approving the plan.
Then you explain your vote. Then you go on the record. It gets recorded in the minutes. Explain your vote. Explain why you're voting no, rather than simply abstaining. If you want to make sure that the public is fully aware and understands what you were considering in casting that no vote. If you want to make that perfectly clear and not subject to speculation, then you're expressing.
That seems reasonable, Keith, but I'm not sure it's mandatory. In the sense, like I agree with you. That would be sensible to just vote no. I can see why you would, but are we saying that commissioners can't abstain on the grounds that they think we shouldn't be voting on a question?
Can we add a qualification to it so that ordinarily commissioners should not abstain unless they have insufficient information and leave it somewhat open-ended? Would that satisfy everyone?
Yes.
Sounds fine to me. I think.
You're not trying to define what narrow exception might exist.
I think it, I won't continue to press the point, but I think it misses the overriding concern here is that the way I'm thinking about this is one thing, there's no question, it's our duty as commissioners to vote. That is our overarching duty, to vote on those matters which we are required to vote on. That's the primary thing. Knowing that, it seems there are going to be times where you must recuse because of conflict of interest. No question asked. But then you get to this more arguably nebulous thing, the abstention. But if you understand the narrowness of the permissible grounds for an abstention, you don't have enough information. I think the public is entitled to know what information you didn't have that precluded you from voting. And that, as Keith said, and once you identified the information you didn't have, you prevent the staff from providing the information so that you can in fact discharge your obligation to vote, even if it means when you get that information, you're compelled to vote no.
Hey, Nancy, I think
that's what I think gets lost here.
I agree with your analysis, but I'm troubled because I don't think that we as the commission can tell commissioners that they can't vote a certain way. Like voting to abstain.
I don't think I'm telling anybody to vote a certain way.
Well, it says the only reason you can abstain is X.
Well, that again, I think, I don't know where I got that from. And
Yeah.
I must, Keith, maybe and I'm not attributing to you, but I thought I heard that from somebody because I didn't know that until I started hearing about rules of parliamentary procedure and
It's
the
come
like.
up in the past. It's definitely come up.
The second clause does allow the commissioner to explain the reason. And it contemplates having a reason perhaps other than insufficient information. And there may be a principal basis. And I think the way to resolve it is simply to say ordinarily or absent special circumstances, however we want to qualify it, but not completely close the door.
Yep.
On the possibility that maybe something
that would satisfy me.
So so Robert's Rules of Order lists 6 reasons why a person should abstain from voting. Not could abstain from voting. I sort of am going to what Ava is saying, which is, like we're kind of saying the only reason you can abstain, but there are other reasons. Yeah, I'm not prepared to talk on because I'm just looking at them now, but I just I think we should all be trusted to vote if we have enough information to vote, and that if we're not voting, then it's because I guess mostly lack of insufficient information, but it could be based on like just not agreeing with the conversation. I've seen this during the meetings, and I've seen commissioners not being challenged as why you're abstaining and taking offense to that. So I think maybe this is meant to address that, but I just think we should be trusted. I don't think we need that policy. I guess I'm not in agreement with it, but yeah, I'm not in agreement with adding that to the policy that you have to say why you're abstaining. Most of us are more than eager to vote on everything, and it's not been an issue with this commission, except for a couple of circumstances way in the beginning of me joining the commission, and I'm not talking just about me or that I've seen it only a couple of times in the beginning. So yeah, I don't agree with the language being in there, but I'm one vote, so
Well, no, I was gonna say, do we have, since we have the full, even though this is a committee meeting, not a commission meeting, and we're not taking any votes, this is for discussion and recommendation purposes only, but I think it's still useful to know if the sense of this group is that two of the members would prefer to leave the language to say that nothing to say, they have to say why they're abstaining.
Well,
That's,
if
that's
I'm
the,
if I'm number two, I'm happy with the language saying you have to say why you abstain. I just wanted the word ordinarily inserted into the first sentence there, as Cindy
okay.
suggested.
And if the general reason is because I don't have enough information, that's all you have to say. But in your case, you could say I'm abstaining because I think the matter's not appropriate for motion.
Yeah.
Okay. Are people okay with that?
Leave it in. I'll give leaving it in or leaving it out.
She's good either way.
I think, Len, what did you want? I thought it was going to be left in with the understanding all you had to say is why, nothing more. And why is not enough information if that's the reason.
We can't hear you, Commissioner Austin. You're
And you're
muted.
moved.
You know what, instead of getting the percentage of salary we get, if I could just get a nickel for every time I forget to unmute, I'd probably be doing it better. But seriously, I think, you know, we're big boys and girls, and I think we have the ability to discern when we should and when we should not. And if there's a problem, certainly the chair or somebody else can talk privately with a fellow commissioner and find out what's going on. I just don't think it's something that should be mandated.
Okay. We will recraft accordingly.
If I may, it is fast approaching 1:30, and I have a 2:00 mediation since we were supposed to be finished by 1:30. So I just wanted to make
Okay.
you aware.
I didn't know we had a fixed stop time, but not that I'm objecting. So, but if you need to leave, we have a quorum, and if anybody, should we take a break?
I also,
Maybe
yeah, I was going to say,
executive
I know
session.
commissioners don't need to eat or drink, but staff may at some point have biological
I think we'll go
needs.
into
So
executive session with particular.
Okay, well, all right, so let's finish with the last bit of this policy, this procedure, which was, again, nobody asked for section 8. But I figured it was the kind of thing that there's no harm in saying it, so that it's just, all it is the conduct expected of members. But, and so I know Claudia wanted to delete bullet 5, but then said perhaps include members being cognizant of the time frame, avoid repetitive comments, and respecting others' viewpoint. I thought that was a good add. But anybody else have objections, strong feelings, additions, whatever to this language?
I mean, I don't really think it's necessary. I mean, I think we are expected to conduct ourselves professionally. And this, much of what's here just talks about professionalism. And I don't think we need to have written rules to tell people they have to be professional where we're at an ethics commission meeting.
Okay.
We expect this behavior, but I don't think it should be written, and it's necessary to write it down. It almost suggests that we don't know what we're supposed to do, and we have to put it in writing.
had issues with 3. And on 2, people use electronic devices as a natural course of living, and we should avoid that. And sometimes we don't treat each other with respect. Sometimes we just don't. I mean, sometimes we get personal attacks. That's not necessary. So I don't know if I think that this should not be. And again, we're not talking about this particular group. We're talking about policy. Some things, like I didn't think that 5 was it 5? I didn't think 5 was necessary.
I thought your point was well taken to take that out.
I mean, how often do we use our phones? I mean, we use our phones, and we should. Learn to refrain from speaking over one another. That was a painful lesson too. I mean, I don't maybe.
If everybody else feels that it's necessary, I mean,
I think we should go back and relook at the list and come up with a narrower list with more, as opposed to all 8. But I think that this section should be included, but maybe not all the specific items in them.
Chair, Vice
I mean,
Chair.
should we be telling people that they should read the materials?
Maybe not.
That's a given.
Yeah. I go ahead, Ava. I'm sorry, Ava, go ahead.
You're muted now.
You're muted, yeah.
Len, I'm giving you a run for your nickels. So I don't really have strong feelings either way, whether we keep this or don't keep it. I would suggest though that if we do keep it, we delete the one about avoiding sidebar conversations, because I think that calls for defining sidebar conversations, and I don't want to get into that. Sometimes I found it's really helpful to be able to lean over to another member and say, "We're on page 4," and
Right.
I want people to keep doing that. That's just
All the
really
time.
and
Can I
sometimes. And the other thought I had was that
We're reading this.
right, like
Can I
on
make a suggestion to piggyback on what the chair was saying, though? It seems to me, we've already had the discussion we need to have about this. I mean, what we really needed was to be mindful of the fact that we all need to be thinking about these things, but do we have to write it down? No. I mean, I think that
That's right.
we've just had in an open session, a discussion about the importance of doing all these things and treating each other with respect and the like. That's enough.
Yeah,
I mean,
yeah.
and that, take it, my suggestion might be, take it out. We've done the thing, we put put it in everybody's head that maybe we fall short sometimes on some of these things. We don't want to do that, and we'll work harder not to do that.
would
And the
certainly
chair will
support
no
taking it
doubt, as the presiding officer of the meeting, the chair will no doubt remind us of when we might be outside of
Yes.
the bounds of
Yeah.
That's right.
our expected decorum.
I think, is everybody agreeable to that?
Yes.
Good.
I will agree.
Okay, well then, can I we would like to move into executive session for the purpose of discussing legal advice that we have been given and to so I'd like to make a motion to enter executive session pursuant to Public Officers Law, Section 105, to discuss some legal advice and a matter relating to personnel. Do we have a
So
motion to
moved.
that? We have a second. I saw Commissioner Austin. Yes, seconded. Motion is approved. We're going into executive session.
We're gonna vote.
Oh, yeah. Do we have a vote? All in favor, say aye.
Aye.
All opposed? Motion carries unanimously to the extent some of us are not, well, the motion carries unanimously. We're going to enter into executive session now, and we will come back following that session with the public announcements from our executive session. Thank you.
You are live.
Welcome back to this meeting of the Administration Committee. I would now like to ask the Executive Director to read out make the public announcement from the executive session we just held.
Thank you, Commissioner. In executive session, the Administration Committee discussed legal advice related to proposed meeting rules and also discussed matters related to personnel.
Thank you. That concludes this meeting. Unless there's any other business, I would ask for a motion to adjourn. Do we have a motion to adjourn?
Yes, Commissioner Edwards.
Okay, and I'll second that. All in favor, say aye.
Aye.
The motion is adjourned. Thank you.
The motion is
The motion is carried.
Carried.
The meeting is adjourned. Thank you.
Meeting is adjourned. You got
Thank
there.
you.
Yeah, thank you.
Everybody do well.